नमस्कार। अधिवक्ता परिषद 30 हजारी यूनिट की तरफ से आप सभी लोगों का आज के कार्यक्रम में बहुत बहुत स्वागत है। मैं ऋतु शर्मा कौशिक अधिवक्ता परिषद की तरफ से आप लोगों का बहुत बहुत स्वागत करती हूँ। अधिवक्ता परिषद में मेरे ऊपर वाइस प्रेसिडेंट और स्टडी सर्कल इंचार्ज का कार्यभार है। हमारे बीच में अधिवक्ता परिषद के प्रेसिडेंट 30 हजारी यूनिट के प्रेसिडेंट श्री नरेंद्र कालरा जी और सेक्रेटरी अधीश जैन जी जुड़े हुए हैं। मैं उनका बहुत बहुत स्वागत करती हूँ। आप लोगों का स्वागत है। हमारे बीच में हमारे आज के ऑनरेबल स्पीकर श्रीमती सुनीता जैन ओझा जी और MS स्वामी बीरबल जी जुड़ चुकी है। मैं आप दोनों का भी बहुत बहुत स्वागत करती हूँ। नमस्कार। सबसे पहले मैं जितने भी हम लोग हमारे साथ जुड़ चुके हैं उन सबका स्वागत करती हूँ और धन्यवाद देती हूँ कि आप लोगों ने अपने बहुमूल्य समय में से हमारे इस कार्यक्रम में जुड़ने के लिए समय निकाला। आप सबसे अनुरोध है कि वंदे मातरम राष्ट्रीय गीत के लिए कृपया खड़े हो जाएं और हमारा साथ दें। राष्ट्रीय गीत के लिए मैं ज्योति जी, चेताली जी और उमा जी को आमंत्रित करती हूँ। कृपया वर्चुअल मंच पे आएं और राष्ट्रीय गीत करें।
माइक अनम्यूट कर लें। हाँ जी, अब ठीक है।
वंदे मातरम सुजलां सुफलां मलयज शीतलां शस्य श्यामलां मातरम वंदे मातरम शुभ्रज्योत्स्नां पुलकितयामिनीं फुल्लकुसुमिता द्रुमदलशोभनीं सुहासिनीं सुमधुरभाषिणीं सुखदां वरदां मातरं वन्दे मातरं। भारत माता की जय।
अब मैं हमारे प्रेसिडेंट श्री नरेंद्र कालरा जी से अनुरोध करूंगी कि इस वर्चुअल मंच पे अधिवक्ता परिषद का परिचय हम सभी को दें।
नमस्कार, मैं नरेंद्र कालरा अधिवक्ता परिषद का छोटा सा परिचय देने के लिए मुझे कहा गया है। तो परिचय बहुत संक्षिप्त में दूंगा क्योंकि बाकी आज अधिवक्ताओं को जो हमारे गेस्ट स्पीकर हैं उनको सुनने में आनंद आएगा। तो अधिवक्ता परिषद की स्थापना श्रीमान दत्तोपंत ठेंगड़ी जी ने 7 सितंबर 1992 में की। वो एक बहुत बड़े दार्शनिक थे। उन्होंने सोचा कि भाई अधिवक्ताओं के जो अधिकार हैं इनको और कैसे बेहतर बनाया जा सकता है, कोर्ट के एटमॉस्फेयर को और कैसे बेहतर बनाया जा सकता है। ये उस वक्त उनकी सोच थी 1992 में। अधिवक्ता परिषद एक रजिस्टर्ड सोसाइटी है जो सोसाइटीज एक्ट के अंदर बाकायदा रजिस्टर्ड है और ये जो इसका ऑब्जेक्ट है वो है भारतीयता की वैल्यू को अपने अंदर अपनाना, वकीलों में अपनाना, कोर्ट के एटमॉस्फेयर को अच्छा करना और जुडिशरी में जो कमियां हैं उनको भी नियत कर रहे उसमें उसको इम्प्रूव करना धीरे धीरे करके। अब इसकी इकाइयां तालुका से लेकर सुप्रीम कोर्ट तक सब कोर्ट में हिंदुस्तान भर में है। इसकी एक त्रिवार्षीय बैठक चलती है जिसको नेशनल काउंसिल फॉर अधिवक्ता परिषद बोलते हैं। वो हिंदुस्तान के अलग अलग शहरों में होती है, अलग अलग स्टेट्स में होती है और ये वकीलों की वो बॉडी है जो किसी पॉलिटिकल कनेक्शन से बहुत दूर है और केवल वकीलों का भला, न्यायिक प्रणाली को, न्याय प्रक्रिया को सुधारने का भला, सुधारने के लिए क्या हम कर सकते हैं उस विषय में सोचती है और काम करती है। तो इसके जो क्या कहते हैं, जो 5 काम है जो अधिवक्ता परिषद नियमित रूप से करती रहती है अपने वकीलों का मनोबल बढ़ाने के लिए, उनमें जागृति लाने के लिए और उनको उन विषयों से परिचित कराने के लिए, जो विषय इस समाज में नए हैं, उनमें कोई लॉ में चेंज होता है, इस तरह की बात करने के लिए हम बात करते हैं। तो उसमें सबसे पहला आयाम है जिसके लिए अधिवक्ता परिषद दिल्ली में कार्यक्रम होते रहते हैं, वो है स्टडी सर्कल। स्टडी सर्कल हर यूनिट में, चाहे वो तालुका की है, चाहे वो डिस्ट्रिक्ट कोर्ट्स की है, चाहे वो सुप्रीम कोर्ट है, चाहे वो हाई कोर्ट है, एक अधिवक्ता परिषद स्टडी सर्कल के नाम से कार्यक्रम आयोजित करती है, जिसमें महीने में एक बार, ये टेंटेटिव है, महीने में एक बार अपन लोग मिलते हैं। जैसे आज अपन मिले हैं, और आज हमारे को रावी बीरबल जी का और सुनीता ओझा जी का सुनने को मिलेगा कि वुमेन हरासमेंट ऑफ वुमेन इन वर्क प्लेस। तो इसी तरह के अलग अलग विषय लेते हुए हम ये स्टडी सर्कल के नीचे काम करते हैं। दूसरा है PIL, पब्लिक इंटरेस्ट लिटिगेशन। बहुत सारी पब्लिक की प्रॉब्लम्स रहती हैं जो समाज में हमारे को देखने को मिलती हैं, तो उन पे भी हम कार्य करते हैं। एक अपनी टीम अलग से बनाई हुई है अधिवक्ता परिषद ने हर इकाई में, जो पब्लिक इंटरेस्ट लिटिगेशन को देखती है। थर्ड और जो मोस्ट इम्पोर्टेंट है वो है न्याय प्रवाह मैगजीन। ये त्रैमासिक है, और इसमें हम जो कुछ करते हैं अलग अलग भारत की यूनिट में जो जो होता है उसका संक्षिप्त रहता है। और इसमें बहुत अच्छे जो हमारे में लिखने वाले वकील हैं, वो एक आर्टिकल लिखते हैं, नए कानून जो बनते हैं उन पर जानकारी इत्यादि देते हैं। फोर्थ इज न्याय केंद्र। न्याय केंद्र की स्थापना इस उद्देश्य से की गई है, जो इंडिपेंडेंट चलता है, जैसे मेडिटेशन सेंटर चलता है, ऐसे न्याय केंद्र अपन सब लोग मिलकर चलाते हैं। न्याय केंद्र में पंक्ति में खड़े आखिरी व्यक्ति तक न्याय पहुंचे, ये हमारी धारणा रहती है। और इसी को धारित कर हम फ्री में, मुफ्त में लीगल एड प्रोवाइड करते हैं जो हमारे न्याय केंद्र में आते हैं। आखिरी है विधायिका। ये भारत सरकार को एडवाइजरी देती है, जो कानून बनने चाहिए, जो रेजोल्यूशन पास हो जाते हैं, उस विषयों में चर्चा करती है, और इन पे चर्चा करने के बाद वो भारत सरकार को हम सबमिट कर देते हैं। तो ये था संक्षिप्त परिचय अधिवक्ता परिषद का। मैं ऋतु से कहूंगा कि आगे का कार्यक्रम फिर से सुचारू रूप से चालू करें। ओवर टू ऋतु जी। ऋतु जी।
धन्यवाद नरेंद्र जी। हमारा आज का विषय है सेक्सुअल हैरेसमेंट ऑफ वुमेन। सेक्सुअल हैरेसमेंट एक बहुत ही कॉमन प्रॉब्लम है सभी महिलाओं के लिए, चाहे वे किसी भी प्रोफेशन से जुड़ी हुई हो। उसी से निजात दिलाने के लिए सेक्सुअल हैरेसमेंट एक्ट गठित किया गया, और आज हमारी दो ऑनरेबल स्पीकर्स इसी बारे में, इसी विषय पर हमारे को कुछ रोशनी प्रदान करेंगे। सबसे पहले मैं श्रीमती सुनीता ओझा जी को आमंत्रित करूंगी और उनका एक परिचय देना चाहूंगी संक्षिप्त मैडम के बारे में। Sunita Oza ji is a practicing lawyer before Supreme Court of India, and she is also practicing before various high courts. She graduated from Mirinda House College. She took her law degree from Faculty of Law, Delhi University in 2003. She is an active member of the Supreme Court Bar Association, and there are so many reported judgments जिसमें मैडम ने अपीयर हुई है, आर्ग्यू किया है, असिस्टेड। She is a senior counsel on the panel of Union of India and appeared regularly for various union ministries and departments before High Court of Delhi and other high courts also. She was appointed as an additional standing counsel for South Delhi Municipal Corporation in the year 2018 and panel counsel for DDA in 2020. She worked with various government bodies also. She has been knowledge partner with organizations like Federation of Indian Industries, NCR Chambers of Trade and Commerce, and conducted regular workshops on legal issues affecting industries, including gender, diversity, and inclusions. She has been awarded Packard Fellowship by International Institute of Education, USA, for her work on promotion of human rights and contributed regularly to public debate on policy matters in the print and TV media. She is an avid tracker. She completed her tracking in year 2018 and was a part of Birding Tree in 2018. I welcome Sunita ma'am. मैं सुनीता मैम का इस कार्यक्रम में बहुत बहुत स्वागत करती हूँ।
सबसे पहले तो मैं आप सभी मेरे जो हमारे मित्र और सीनियर हैं प्रेजेंट अधिवक्ता परिषद से, और जो हमारे मेंबर्स जो सुन रहे हैं, पार्टिसिपेट कर रहे हैं इस प्रोग्राम में, आप सबका तहे दिल से धन्यवाद देना चाहूंगी। और जैसा कि हमारे बता रहे थे सर कालरा साहब की भी, द स्टडी सर्कल का पर्पस है किस तरह से हम अपना ज्ञान वर्धन करके वी कैन बिकम अ मोर इफेक्टिव पार्टिसिपेंट इन द जुडिशियल डिलीवरी सिस्टम। ये जो आज का विषय है, सेक्सुअल हैरेसमेंट एट वर्क प्लेस, ये मूवमेंट एक तरह से कहें तो ये जुडिशरी ड्रिवन रहा। विशाखा की जजमेंट आई 1997 में, सुप्रीम कोर्ट की जजमेंट। मैं थोड़ा सा हिस्ट्री बताना चाहती हूँ क्योंकि वो बैकग्राउंड है, और वो बैकग्राउंड इसलिए भी जानना जरूरी है क्योंकि वो वहां पर सुप्रीम कोर्ट ने अपनी जजमेंट के द्वारा एक कानून लिखा, और वो कानून रहा हम इफेक्टिव टिल 2013 जब लेजिस्लेचर ने ये एक्ट लाई और अमेंड किया। अब इसकी सबसे बड़ी खासियत क्या है? हमारा कॉन्स्टिट्यूशन हमें देता है राइट टू लाइफ, आर्टिकल 21, राइट टू इक्वालिटी, आर्टिकल 14, एंड राइट टू वर्क विच इज आर्टिकल 19। ये जो तीनों ट्रायंगल हैं, तीन अधिकारों के, ये सब का जो सम्मिलन है वो इस पर्टिकुलर राहत देने वाले कानून के तहत महिलाओं का जो अधिकार है उसको सुरक्षित किया गया। कैसे किया गया? सिंपल बात है, कोई भी महिला जहां भी काम कर रही है उसके एम्प्लॉयर की रिस्पॉन्सिबिलिटी है कि उसको एक सेफ वर्किंग एनवायरनमेंट दें। आप अभी जो रावी जी का प्रेजेंटेशन होगा उसमें वो सेक्शन वाइज सभी हमारे जो सुनने वाले हैं उनको लेके जाएंगी सेक्शन वाइज ये की डिटेल्स में। मैं बस आपको एक ओवरव्यू देना चाहती हूँ। वो ये है कि जो इस एक्ट में है कि भाई एवरी एम्प्लॉयर इज रिस्पॉन्सिबल, चाहे वो प्राइवेट हो चाहे वो पब्लिक ऑर्गेनाइजेशन हो, हर तरह का कोई भी तरह की अगर परेशानी हो रही है जिससे which can fall under the definition of sexual harassment at workplace, उसका redressal mechanism यहाँ पे भी बताया गया है। तो सबसे पहला छोटा सा एक सवाल उठता है कि भाई है क्या सेक्सुअल हैरेसमेंट? लेट्स बी क्लियर अबाउट व्हाट वी मीन व्हेन वी से सेक्सुअल हैरेसमेंट एट वर्कप्लेस। तो मैं एक छोटा सा ये ट्रायंगल आप सभी देख रहे हैं, ये ट्रायंगल जरा इसे ध्यान रखिएगा। इसमें तीन बातें हैं। सबसे ऊपर है हॉस्टाइल एनवायरनमेंट, एक तरफ है अनवेलकम कंडक्ट, और तीसरा है क्विड प्रो क्यो। डेफिनेशन है जो हमारी सेक्शन की बहुत लंबी है और बहुत डिटेल्ड है, इंक्लूसिव और एग्जॉस्टिव है। तो लेकिन ये ट्रायंगल अगर हम ध्यान रखें तो जहां भी कोई सवाल उठता है तो सबसे पहले कि क्या वो बिहेवियर, क्योंकि हम किस चीज की बात करते हैं सेक्सुअल हैरेसमेंट में, एक कॉन्डक्ट, एक बिहेवियर, इसकी बात करते हैं एट वर्क प्लेस। तो बिहेवियर जो है क्या वो अनवेलकम है, क्या वो क्विड प्रो क्यो है ना? क्विड प्रो क्यो का सिंपल मतलब ये होता है कि आप मेरे लिए कुछ करें तो हम आपके लिए कुछ करेंगे। तो क्विड प्रो क्यो टिपिकली ऐसे सिचुएशन में अराइज करता है जहां पर पावर इम्बैलेंस हो, जहां पर आप जो रिस्पोंडेंट हैं उनके पास कुछ ऐसी शक्तियां हैं, पावर है, जिसके थ्रू मेरा वर्क प्रोफाइल, मेरा वर्क प्लेसमेंट, मेरे प्रमोशंस, कुछ भी इफेक्ट हो सकता है। तो क्विड प्रो क्यो हो गया। अगर कोई बिहेवियर है वो क्विड प्रो क्यो में आता है कि ये इसलिए बोला गया कि अगर आप इसको करती हैं तो आपको एक पर्टिकुलर फेवरेबल ट्रीटमेंट मिलेगा और नहीं करती हैं तो अनफेवरेबल ट्रीटमेंट मिलेगा। इस तरह के कंडक्ट आपके इस ट्रायंगल के अंदर आएंगे, क्विड प्रो क्यो और अनवेलकम क्विड प्रो क्यो। जब ये दोनों तरह के बिहेवियर मिल जाते हैं तो एक हॉस्टाइल वर्क एनवायरनमेंट क्रिएट होता है। हॉस्टाइल वर्क एनवायरनमेंट, बहुत सारी स्टडीज हुई हैं आपकी जो कंपनी प्राइवेट लेवल पे स्टडी, उनसे पता चलता है कि विमेन सेक्सुअल हैरेसमेंट एट वर्क प्लेस फॉर विमेन, व्हाट इट डज इज, one, it prevents women from effectively participating and discharging their duties. अगर वो इफेक्टिवली अपनी ड्यूटीज नहीं डिस्चार्ज कर रही हैं तो डायरेक्ट इंपैक्ट प्रोडक्टिविटी पे आता है। इट ऑल्सो लीड्स टू एट्रिशन। अगर बिहेवियर कॉन्डक्ट इस तरह का है, अगर उस महिला के पास ऑप्शन नहीं है कि वो कंटिन्यू कर सके, तो वो बहुत बारे ऐसे इंस्टेंसेस आते हैं कि वो डिसाइड करती है कि इट इज बेटर नॉट टू वर्क। एट्रिशन, एक स्किल्ड वर्कफोर्स एक गंवा दिया, दैट कैन ऑल्सो हैपन बिकॉज ऑफ सेक्सुअल हैरेसमेंट एट वर्क प्लेस। जो मेंटल ट्रॉमा होता है फॉर द वुमन एंड ऑल्सो फॉर हर फैमिली, दैट आज जो मेंटल इश्यूज है, मेंटल हेल्थ का इश्यूज नेशनल लेवल पे रिकॉग्नाइज हुआ। अभी बजट प्रेजेंट किया हमारे फाइनेंस मिनिस्टर में, उसमें स्पेशल प्रोविजन किया गया है फॉर मेंटल हेल्थ। तो मेंटल हेल्थ इज रिकॉग्नाइज्ड एज अ पॉलिसी ऑफ द स्टेट कि हम एड्रेस करेंगे इशू को, और सेक्सुअल हैरेसमेंट का इम्पैक्ट मेंटल हेल्थ पे भी पड़ता है। तो जब हम एक अच्छे सेफ वर्किंग एनवायरनमेंट की बात करते हैं, तो वो ऐसे वर्किंग एनवायरनमेंट में ये it should be free from any conduct which can amount to sexual harassment at workplace. And when we say sexual harassment at workplace, it means any unwelcome conduct, any quid pro quo conduct, or any conduct which creates a hostile environment for the women at workplace. So ye ho gaya sexual harassment. As a lawyer, because I assume that most of us who are participating today in this program, we derive our motivation, inspiration, and our livelihood by practice of law. लोग समस्या लेके हमारे पास आते हैं। सबसे फर्स्ट लेवल पे महिलाएं भी आ सकती हैं, पुरुष भी आ सकते हैं। तो सबसे पहले हमें उन्हें एडवाइस करना पड़ता है कि भाई क्या आप जो जिस कॉन्डक्ट की बात कर रही हैं, डज इट फॉल विद इन द पैरामीटर्स ऑफ सेक्सुअल हैरेसमेंट एट वर्क प्लेस। तो डेफिनेशन की समझ रखना जरूरी है। सेक्शन 3, प्लीज गो थ्रू एंड वी विल ऑल्सो डू इट इन ड्यूरिंग द कोर्स ऑफ टुडेज वेबिनार। दैट इज द डेफिनेशन। नंबर 2, what are the options that are available to a woman who is undergoing sexual harassment at workplace? एक तो 2013 क्रिमिनल अमेंडमेंट एक्ट आया जस्टिस वर्मा कमेटी की रिपोर्ट के बाद, और निर्भया केस के बैकग्राउंड में उसमें आपका जो एक अमेंडमेंट हुआ, वन ऑफ द अमेंडमेंट वाज आल्सो incorporating sexual harassment at workplace as a penal offense. तो वो एक penal offense हो गया, उसके लिए FIR दर्ज कर सकते हैं और कंप्लेंट दर्ज कर सकते हैं और इन्वेस्टिगेशन। सो दैट मूव्स अलोंग विद आवर जो हमारी जो प्रोसीजर है, क्रिमिनल प्रोसीजर, उसके साथ। बट हम जो प्राइमरीली आज डिस्कशन कर रहे हैं, टू द बेस्ट ऑफ माय अंडरस्टैंडिंग, वी आर टॉकिंग अबाउट Sexual Harassment at Workplace, Prevention, Prohibition and Redressal Act 2013. This is a civil remedy. It is a civil remedy which woman can take without going to the police station, without involving police. आप अपने एम्प्लॉयर के पास ये कंप्लेन रजिस्टर करते हैं। आपकी इंटरनल कमिटी होती है, वहां पे ये कंप्लेन रजिस्टर होती है। तो एक्ट में मैंडेटरी कर दिया गया है कि हर ऑर्गेनाइजेशन, every organization having 10 or more employees. अभी एक सवाल यहां और पूछता है कि भाई महिलाएं नहीं हैं, एक भी महिलाएं नहीं हैं, तब भी क्या जरूरी है? बिल्कुल, क्योंकि एक्ट कहता है 10 or more employees. It is not necessary that the organization should have a woman employee in order to set up a redressal mechanism for redressal of grievances arising out of a sexual harassment complaint. तो 10 से ज्यादा है तो करना है, कमिटी बनानी है और आपको redressal mechanism देना है. इसका लॉजिक एक और है, वो लॉजिक ये है कि इसमें थर्ड पार्टी लाइबिलिटी भी होती है. तो सपोज करिए मैं एक छोटा ऑफिस चला रही हूँ, इट कैन बी अ लॉयर्स ऑफिस with a 10A or a small law firm with 10 people, perhaps no women employee. But कोई अगर मुझे विजिट करने आ रहा है, a client, a intern, anybody. So अगर उनके साथ कोई ऐसी घटना घटती है तो वो भी मुझे इन्वेस्टिगेट करनी है अपनी इंटरनल कमिटी के थ्रू. So because there is a third party liability, one cannot say that if we do not have women employees, we do not have to constitute an internal committee. You have to constitute an internal committee. You have to keep the procedures in place. So, क्या है ये internal committee? Internal committee is like eyes and ears of an organization. It's an eye and ear of an organization to watch. It's a standing committee. It's not an ad hoc committee. ऐसी बात नहीं है कि जब कोई कंप्लेंट आएगी फिर हम कमिटी बनाएंगे. It's a standing committee. It's a part of the organization. ये अपनी रिपोर्ट देती है जो बोर्ड को जाती है, जो आपकी जो कंपनीज एक्ट में जो आपकी कंप्लायंसेस हैं उसमें ये रिपोर्ट को शामिल होना है. So that is a part of it's a part of the legal mechanism now. अब ये है कि इट्स एंड द कमिटी एक तो है कि भाई कंप्लेंट आएगी, इन्वेस्टिगेट करती है. अदरवाइज ऑल्सो दे सी कि क्या कैसे हो रहा है कंप्लायंस, बिकॉज मोस्ट ऑफ द ऑर्गेनाइजेशंस हैव नाउ अडॉप्टेड व्हाट इज कॉल्ड अ जीरो टॉलरेंस पॉलिसी, कि हम किसी तरह ऐसे व्यवहार को नहीं बर्दाश्त करेंगे which amounts to sexual harassment at workplace. Now, in order to implement this zero tolerance policy, it's important कि इसको vigilant होकर के implement किया जाए. So that is the task which your internal complaints committee does. उनकी मीटिंग होती है रेगुलर. और यहाँ पे एक बहुत इंपॉर्टेंट रोल लॉयर्स का फिर आता है, क्योंकि है तो ये इंटरनल आईज एंड ईयर्स, लेकिन इसमें एक एक्सटर्नल मेंबर भी रहते हैं. और ये एक्सटर्नल मेंबर इन मेजॉरिटी ऑफ द केसेस आर लॉयर्स और दोज हु आर ट्रेन्ड इन लॉ, हु आर फेमिलियर विथ लॉ रिलेटिंग टू लेबर इश्यूज, विमेन्स इश्यूज. तो ऐसे यहाँ पे बहुत सारे हमारे लॉयर्स फ्रेंड्स हैं हु आर अ पार्ट ऑफ द इंटरनल कमिटी. तो उनके लिए भी अपने आप को इस पूरे कानून से, इस पूरी कानून की जो व्यवस्था है, जो स्ट्रक्चर है, उससे फेमिलियर रखना खुद को, ताकि वो स्टेप वाइज प्रोसेस विद इन एन ऑर्गेनाइजेशन को गाइड कर सके, स्टीयर कर सकें. तो ये इंटरनल्स कमिटी होती है जो इन्वेस्टिगेट भी करती है. जो इन्वेस्टिगेशन इनकी होती है वो नॉर्मली आपके जो कानून में 2 बातें दी गई हैं, हमारी प्रिंसिपल्स ऑफ नेचुरल जस्टिस फॉलो करना है. That is the principle that you have to follow when you conduct an investigation. So that is about our internal complaints committee. So as a lawyer, we must know what is sexual harassment at workplace. We must know, if we are a part of the internal complaints committee, how the investigation has to be done. कोई complaint आई है, कैसे recommendation जाएगा. और जो तीसरा फेज है वो है कि अगर satisfy नहीं है either the complainant or the respondent, जो भी कमेटी की रिपोर्ट आई, तब वो मामले फिर हमारे बाहर कोर्ट में आते हैं. एपेलेट है, उसके लिए एपेलेट बॉडी बनी हुई है. जैसे दिल्ली में आपकी लेबर ट्राइब्यूनल है जहां पे अपील लाई करती है, वो है एपेलेट बॉडी. जहां पर नहीं है वहां पे लोग डायरेक्टली हाई कोर्ट में रिट भी डालते हैं चैलेंजिंग, और उसके बाद आपका जो इट इज अ जुडिशियल प्रोसेस विच आई थिंक मोस्ट ऑफ अस आर फेमिलियर विद। तो ये तो हुआ ऑर्गेनाइजेशन के अंदर का जो उनकी इंटरनल कमिटी होती है। इसके अलावा हर डिस्ट्रिक्ट लेवल पे एक लोकल कंप्लेंट्स कमिटी होती है। वो ऐसे ऑर्गेनाइजेशंस जहां पे इंटरनल कमिटी नहीं है उनके लिए है, या फिर आपका कंप्लेन अगर एम्प्लॉयर के अगेंस्ट है। तो one of the fundamental principle is that you cannot be a judge in your own cause. Therefore, as an employer, you will not investigate a complaint where you have been, allegations are against you. तो ऐसी complaints के लिए local complaints committee हो गई। तो this is by and large the scope, which of course my friend will take all of us through the clause wise and the section wise. So I would like to now just conclude with three things. One, women at workplace is a reality, number one. Women at workplace is a necessity, number two. अगर हमें अपने देश को एक बड़े ग्रोथ पाथ पे ले जाना है तो 50% जो लोग हैं उनको हम वर्कफोर्स के बाहर नहीं रख सकते, and therefore we need to have a workplace which is safe, which is conducive, and which is effectively protecting the rights of every member, including women. So that therefore it becomes, ये हमारा national interest में है, ये हमारे देश के हित में है कि हम अपने workplace में चाहे जो भी हो, whether it is a domestic worker or it is a CEO of a company, everyone should get a safe work environment and should be able to give their best for the country, for the organization that they're working, because सबके साथ मिलके काम करने में ही सबका विकास है. That is a fact. Now, so therefore, the question is not कि क्यों है ये. The question now is कैसे इसको maximum तरीके से implement करना है. एक छोटा सा मैं ध्यान आपका आकर्षित करना चाहूंगी. The act starts with saying prevention. So the core of the act is actually prevention. And the key to prevention lies in sensitization, in conversation, in training. क्योंकि आप कभी मैं as an IC member also of several committees, I would like to share that the spectrum, जो complaints की spectrum है, वो बहुत wide है. On one hand, आप ऐसे भी complaints देखेंगी, ऐसे भी incidents जो देखेंगी जो देखने से बहुत minor लगते हैं, बहुत obtuse लगते हैं, बहुत small लगते हैं. In fact, अगर रूपन देवल बजाज के केस से आप सभी वाकिफ हों, तो ये बता दूं कि पहले वो केस डिसमिस इसलिए हो गया था क्योंकि आईपीसी में एक प्रोविजन है कि अगर क्राइम इतना हल्का है कि उसको हम we can't go further with it, तो जब वो she was slapped on her posterior, उनका कंप्लेंट रिजेक्ट हो गया था उनका, और वो जब फाइनली उसमें आकर के सुप्रीम कोर्ट ने डिसीजन दिया और बोला कि नहीं, इट अफेक्ट्स द डिग्निटी ऑफ अ वुमन, और फिर वो पूरा आपका it went back and went through the trial, and of course the rest is a history we are all aware of. So, and how do we then capture this spectrum? जो एंड ऑफ स्पेक्ट्रम पे है, जहां पे जो बिहेवियर एब्सोल्युटली एबोरेंट है, जिसके लिए दिमाग अप्लाई करने की भी जरूरत नहीं है, वो है. दूसरी तरफ ऐसे भी हैं जैसे कमेंट्स. So, you know how this can be prevented only by a regular sensitization program. So and in fact the act ke under section 19 is like a Gita for every employer. It gives you the code of conduct. आपको क्या करना है, पॉलिसी बनानी है, आईसी बनानी है, आईसी के मेंबर्स को ट्रेन करना है, जो आपके ऑर्गेनाइजेशन के लोगों हैं उनको ट्रेन करना है। सेक्शन 19 पूरे जो चीजें एक ऑर्गेनाइजेशन को करनी है वो प्रोवाइड करता है। और ये जरूरी इसलिए भी करना है कि ये जो रिस्पॉन्सिबिलिटी डाली गई है एम्प्लॉयर पे, एवरी एम्प्लॉयर इज रिस्पॉन्सिबल फॉर अ सेफ वर्किंग एनवायरमेंट। हाउ डू यू डिस्चार्ज? जैसे एविडेंस में हम ओनस डिस्चार्ज करते हैं, अगर हमें प्रूव करना है तो हम अपना वो ओनस डिस्चार्ज करते हैं। तो एज एन एम्प्लॉयर you have to discharge. And how do you discharge? By showing that I have done A, B, C, D, E, F. And section 19, therefore I say it is the Gita for every employer. If they must follow every word that is written there and follow it in letter and spirit in order to truly implement. तो अगर हम prevention पे काम करेंगे तो हमारा काम redressal पे बहुत कम हो जाएगा। So that is एक और final. The entire concept of sexual harassment of a woman is based on, it is not based on intent, it is based on the perception. कि जो woman has gone through, whatever she has gone through, उसने उस act को कैसे perceive किया। अगर मुझे वो act harassing लगा, मुझे वो एक्ट अनवेलकम लगा, मुझे लगा कि इस एक्ट के थ्रू मुझे कुछ तरह से हिंट दिए जा रहे हैं, तो इट इज माय परसेप्शन व्हिच इज इंपॉर्टेंट। इट इज नॉट द इंटेंट। इट इज नॉट इनफ टू से कि जी ये मेरा मतलब नहीं था, आई डिड नॉट मीन टू डू इट, दिस वाज नॉट द इंटेंट। इट इज द परसेप्शन एंड द एक्ट इटसेल्फ सेज इट्स द परसेप्शन ऑफ द वुमन दैट इज इंपॉर्टेंट। एंड व्हाई इज दैट इंपॉर्टेंट? क्योंकि हम अलग अलग एक वर्क प्लेस पे हम अलग अलग क्षेत्र से आते हैं, अलग अलग इकोनॉमिक सोशल बैकग्राउंड से आते हैं, सबका टॉलरेंस एक्सेप्टेंस लेवल भी अलग अलग है। एक हमारे पास एक कंप्लेंट था जिसमें महिला ने कहा कि भाई ये बातचीत करते समय अपना हाथ कंधे पे रख देते हैं। अभी बाकी सभी लोगों ने, विटनेसेस ने कहा कि नहीं, बट दिस इज नॉर्मल, इट्स लाइक इट वाज बॉम्बे, आई मीन इट्स फाइन। एंड शी सेड, मैम, the village that I come from, no man is allowed to touch me except my father and my brother. So I find it offensive. She's not wrong in her perception. And therefore, at the end of the day, what this act demands is a good behavior, good conduct at a workplace, a conduct जिसको करने के बाद no one will be ashamed to face either their own family or their own children. Or even if it gets reported, it is कहते हैं often कि भाई अगर एक conduct is reported on the TV, you will not be ashamed of it. So that is the conduct, that's the kind of behavior that the act is looking at the workplace. इसी के साथ I will hand over the to my friend for the next session. My idea was only to just give a brief overview. And thank you.
धन्यवाद सुनीता जी, आपका बहुत बहुत धन्यवाद। हमारी अगली स्पीकर रावी बीरबल जी हैं। वो पेशे से वकील हैं एंड शी हैज स्पेशलाइजेशन इन लेबर लॉज एंड कॉर्पोरेट लॉज। ऑन द रेगुलर बेसिस शी इज रिप्रेजेंटिंग एंड एडवाइजिंग मल्टीनेशनल कंपनीज, corporates, blue chips, all kind of companies, continentals, PSUs, governments, hospitals, universities, etc. And she is appearing before various high courts. She has a very good number of reported judgments. She has been appointed as amicus curiae several times by Delhi High Court in labor matters, appointed as co-chairman during amalgamation of corporates, also appointed sole arbitrator by Delhi High Court in contractual disputes. She was monthly columnist with India Express from 2012 to 2017, over 80 publications in her name in top newspapers, magazines and journals. She has spoken on platforms such as Delhi Legal Services Authority, Delhi Judicial Academy, Institute of Company Secretaries of India, National Commission for Women, Institute of Chartered Accountants of India, PhD Chambers of Commerce, International Bar Association, New York State Bar Association, National HRD, India International Center, Vigyan Bhavan, Lok Sabha TV, Rajya Sabha TV, NDTV, AVP, IILM, IMT, Delhi Universities, AIIMS, various colleges, etc. I welcome Ravi Birbal ji. Please come on this virtual platform and give more light on this topic.
Thank you for inviting me to your spectacular platform. I'm very humbled to be addressing such esteemed audience, the lawyers in the city today. So we are in the 21st century, and it's so unfortunate that even till now, we have to explain people the difference between right and wrong. The fact that men and women are equal, that how they should behave, that there should not be any discrimination or harassment on the basis of gender. Now, as we all know, a lot of companies are wanting to invest in India. And the first thing that the companies outside look before investing in a country is the ethics that the country and the companies therein follows. It's my view that not just enactment of laws like this POSH Act 2013, even other labor laws, that we have absolute awareness and implementation of these laws across the country, even in the remotest parts of the country. I am sure we can attract lots of more foreign investments. I have prepared a small PPT, which I'll just screen share, on the POSH Act, which has been promulgated and made in effect from the year 2013. I hope it is visible. I hope it is visible. Is the PPT visible?
Yes, ma'am, visible.
Okay. So regarding sexual harassment, we have got two things to look into. First, we have got the Sexual Harassment of Women at Workplace, the Prevention, Prohibition, and the Redressal Act 2013. And prior to this, we had the Vishaka's judgment of 1997. Now, because not following Vishaka's judgment of 1997 did not have any penal consequences. That is, in simpler words, if a company would not follow the guidelines that was laid down in Vishaka's judgment, that what kind of committee should be there, how sexual harassment should be prevented, because there were no penal consequences for not following the judgment. Therefore, Parliament promulgated this Sexual Harassment of Women at Workplaces, and not following the provisions of this act has got very serious penal consequences, which also include cancellation of the registration of the concerned organization. Now, the POSH Act 2013 defines the acts of sexual harassment as under. It says that not just physical contact, but even verbal contact or demand of sexual favors or showing pornography or sending a wrongful WhatsApp message, a wrongful email. So it need not just be physical. Physical, of course, is there, but even it is verbal, or even if it is visual, that would also constitute as an act of sexual harassment if it has been done with wrongful intent and if the perception is also wrong. But there has to be a sexual angle to it. Now, the POSH Act 2013 also talks about certain circumstances that if a male is in a better position than the female, and he may promise a preferential treatment to her, or he may threaten her with a detrimental treatment, or he may threaten her or pressurize her for a future job, for the current job, if he is doing interference in her day-to-day work, if he is making the work environment so hostile and so humiliating that she's not able to carry out the work properly, and such a conduct has to be perpetual in nature, not just in a conduct in isolation, then that would also constitute as sexual harassment. Apart from defining what could be acts of sexual harassment, the POSH Act 2013 specifically states that there has to be a committee in every company, every organization, every establishment wherein there are 10 or more employees. And that internal committee has to be constituted as follows. First, there has to be a chairperson of the committee known as the presiding officer of the company. That presiding officer has to be a senior woman employee of the organization. Apart from that, there have to be 2 more employees from the organization, and the 4th member, that will be an outside member, which can be a lawyer, which can be a CA, a doctor, or even an NGO. So minimum, there have to be 4 people. There can be more than 4 people also. The Act also says that at least half of the people in the committee have to mandatorily be women. So this is how the committee is to be constituted inside the company. And wherever there are 10 or less employees, it does not mean that the people there are remediless. There is even a district committee, a local complaint committee in every district formulated in the country, wherein wherever there is no internal complaint committee formulated, or wherever there are less than 10 employees, or in cases of domestic servants, they can approach local complaint committee of any district or wherever they are situated, taking their complaint to that particular committee. I may also add over here, because often these kind of questions come to us, that what kind of employees would be covered by this POSH Act. So every employee, whether somebody is a regular employee, even casual worker, daily wager, temporary worker, probationer, or somebody who's just coming to your place to work for a few days, whether it's, even a gig worker, platform worker, these things are very popular these days. Every kind of worker, non-worker, manager, CEO would be having the benefit of provisions of POSH Act. Now, although the Act does not lay down the procedure of inquiry, it only says that the inquiry would be conducted as per the rules of the service rules of the organization. But by virtue of various judgments, this is how the inquiry procedure is to be conducted. First of all, the woman gives a complaint in writing. After the complaint has been given, the committee looks into it, and if it feels there is merit in the complaint, then thereafter a proper charge sheet is to be issued to the accused male employee. Even if the committee wants, without even looking into merits, it can still issue a prima facie charge sheet or a show cause notice to the accused employee asking for his reply. Now, here it is very important that the committee should wait for some time for the male employee to reply to the charge sheet. And we personally suggest that if the male employee has not answered to the charge sheet in one go, at least give him two to three chances. Now, supposing if he admits the charges, then the issue is over there. And then depending upon how grave that charge of sexual harassment was, the disciplinary authority can take a penalty based on what the internal complaint committee has recommended. But if the accused employee is denying the charges, he said, no, I have not done anything of this sort, then a full-fledged inquiry is mandatory to be conducted following the principles of natural justice. Now, how is this inquiry conducted? In this inquiry, the accused employee and the victim, they are both called. They are both allowed to give their names of witnesses, documentary proof, and even hearsay evidence, whatever little evidence they have. They are both asked to give their own statements. Then both parties are given, very importantly, which even Delhi High Court in a recent case, which I will be sharing, has said, have to be mandatorily given opportunity of cross-examining each other. Thereafter, depending upon whatever material is there before the inquiry committee, including the cross-examination, the inquiry committee has to formulate a detailed report. It will not be a half-page report or a one-page report. It has to be a very detailed report that this was the evidence, this was the cross-examination, and this is our rationale, our reason for arriving at the conclusion whether the person is guilty or not. Apart from giving the conclusion, the internal complaint committee can also recommend penalty against the accused employee if the charges are proved or if they so feel that woman made a malicious complaint, then they can recommend a penalty against the woman also. I may add over here, if the woman has not been able to prove the charges, that would not mean she made a malicious complaint. There will have to be cogent evidence, sufficient evidence to show that the complaint was malicious. So holding the person guilty and or the complaint is malicious, both findings the inquiry committee is entitled to arrive upon. And after they have given the report, then even now the action cannot be taken. The appropriate disciplinary authority is first required to issue a show cause notice. This we call it as the second show cause notice, attaching the copy of the inquiry report to the accused employee, once again asking for his reply, that why he feels that the report is right or wrong, and even suggesting the penalty that the committee feels or the disciplinary authority feels should be imposed upon the accused employee in light of whatever the accusations have been proved. So proposed penalty, the copy of the report, that must be provided to the accused employee before taking a final action on the matter. Once again, here also we suggest to companies that at least give 2 to 3 chances to the accused employee to reply to the show cause notice, to reply to the inquiry report. Now, after he has replied to inquiry report, right, then thereafter the disciplinary authority may pass a speaking disciplinary action order against the accused employee. Now, I may also add over here, there is slight disturbance in the, I think there is slight disturbance coming. Sorry, yes. So now here may I also add, sorry, there was slight disturbance. Now, before, there is one more thing. Before starting of this whole inquiry and the disciplinary action, if the committee wants, and if it so feels that it wants to settle the dispute between the man and the woman, that is also allowed. But here I may add, if the sexual assault, if the sexual harassment is extremely grave in nature, like it is of physical assault, in such cases, the settlement should not be done. But if it is a case of, misunderstanding, or maybe the charge is not very serious, then there is no harm in reconciling between the two parties. And there should be, after all, the aim of any legislation is peace of mind and righteousness. Now, I may also add over here, normally a person cannot be transferred from one location to another or from one department to another because of any disciplinary action against him. However, POSH Act creates an exception there. So if it's a charge of sexual harassment, the Internal Complaint Committee has been given the power to recommend of transferring of the accused employee or of the victim to another location or another department. Further, the Internal Complaint Committee also has the power to recommend grant of leave to the woman employee for a certain period. They can even recommend a garden leave, that you can sit at home, you will get the salary without working. And further, any other relief like change of department or changing the seat, etc., that can also be recommended in between the inquiry process for the accused employee or for the victim. Then thereafter, after the inquiry has been completed, like I said, the inquiry report is to be given within a period of 10 days to the disciplinary authority. And what all actions can be recommended? So for acts of sexual harassment, actions such as dismissal, removal, just a second, I think there's a disrupting here. 1 second. Yes, for the acts of sexual harassment, the misconduct can be punished as per the service rules, such as dismissal can be given, removal can be given, or even compulsory retirement can be given, stagnation of pay can be given, demotion can be given, even a strict, if the charge is not very serious, even a strict warning can be given. Any kind of penalty that has been stipulated in the service rules of the organization, that penalty can be imposed upon the accused employee. Apart from this, here also again, POSH Act 2013 has a special provision. It says that if the Internal Complaint Committee or the disciplinary authority so feels, it may even deduct some amount of salary from the accused employee's salary, or maybe his legal dues like gratuity, leave encashment, not provident fund. Provident fund, nothing, never it can be deducted. But if the disciplinary authority, inquiry authority so feels, it can deduct an amount of compensation from the salary which is due to accused employee, or his leave encashment, or his gratuity, or his notice pay, and give it to the woman employee as a compensation for mental trauma, loss of opportunity, harassment, for anything they feel appropriate to the woman. And here also, I may add over here, which I said earlier, that, there can be penalties against the woman also if she raises a malicious complaint, but it has been clarified by various courts. And even the POSH Act 2013 says that malicious complaint would not mean if the charges have not been proved. It has to be proved beyond doubt that the complaint was made for malicious reasons. Then apart from this, the POSH Act mandates that the companies every year, they have to submit annual reports. In that annual report, they have to mention as to how many cases of POSH Act have been there in the company. If there has been a nil case, even then the company has to inform the government that, look, in my company, there was nil case. Then further, the POSH Act says, and even as per the latest Bombay High Court judgment, which I will show, screen share the slide, says that the name of the accused and the victim, the name of the witnesses, all the records have to be kept confidential. The report of the inquiry committee is not to be published. It is not to be given to media unless a permission has been taken from the Honorable Court. Further, the decision of the inquiry committee is also not to be published. One more thing everyone may note here is that the committee, the internal complaint committee of the company, has to be there only for a period of 3 years. After 3 years, the committee, the members have to change. So the committee keeps getting rotating after every 3 years. Apart from these basic things, there are some duties of the employer which have been stipulated in the POSH Act 2013. First is that, of course, providing a very safe working environment to the woman employee. Then it also says that if the woman wants that, there are serious charges, and if she wants to take the case to a criminal court, then it is the company's duty to assist the woman employee in every manner, right from the charge sheet FIR to the complete criminal case. They will go along with her in the criminal court, assist her in every possible manner. Then the third very important duty is that on a conspicuous place of the notice board, the policy of the company must be published and the consequences must be informed to the employees. So while it is very important to have a policy of sexual harassment of the company in place, it is also very important to inform the employees. These days, as we all know, companies have this system of intra-board. So if you are not wanting to put up physically the policy on the notice board, and if it is not possible, then you can always put that policy on the intra-board, which can be seen by all the employees. Alternatively, you can also mail them the copy of the policy from time to time. Then further, the Act also says that the internal complaint committee should be given all possible assistance, like they should be given a room, a proper place, the voice should not be going outside, and whatever stenographer if they need, whatever kind of assistance the internal complaint committee member wants, the company has to definitely provide. Then the Act also states that the company must organize workshops from time to time regarding the POSH Act compliances and as to what acts of sexual harassment are, so that the deterrent is created in the organization. People are scared to commit such kind of acts. Then the POSH Act mandates, very important, that if there has been an act of sexual harassment, then mandatorily a disciplinary action has to be taken depending upon the gravity of the misconduct. You cannot let the employee go scot-free. A deterrent has to be created in the company and in the country also. Then POSH Act also says that you have to timely submit reports by the internal complaint committee. And if these compliances are not, complied with, then there can be a fine of 50,000 rupees If there is a repetition of the offense, then there can be double the fine. And if you keep doing it again and again, then if the court wants, or if the labor authority wants, it can even cancel your license of registration of carrying on the business. And once the business license is cancelled, then you cannot carry on that business. So because Vishakha did not have these penal consequences, therefore Parliament promulgated the 2013 Act. And if you do not follow it, it can have very serious repercussions. Now, let us look at some of the important judgments, that may help you do the cases under the POSH Act. So first judgment is of Honorable Supreme Court of State of Haryana versus Ratan Singh. And this is far more prior to coming of the POSH Act. This is on domestic inquiries, that how a domestic inquiry is to be conducted. What kind of evidence has to be there? How does a court look into a domestic inquiry? So State of Haryana, Ratan Singh laid down that all materials which are logically probative for a prudent mind, that can be given in evidence in the domestic inquiry. The State of Haryana judgment also said that, if the inquiry committee has arrived at certain finding, it feels that the employee is guilty or it feels the employee is not guilty, the court ordinarily should not interfere into the inquiry done by the management. The court should interfere only if it is a case of no evidence, that, inquiry committee just had a decision without any evidence, or the court can interfere if the evidence is completely perverse. If this is not the case, then courts do not have the authority to interfere. The review of the committee has to be upheld. However, if it is a case of no evidence or perverse, then of course the court can fully interfere and set aside the report of the inquiry officer. And of course, at the same time, if the principles of natural justice have not been complied with, if person has not been given opportunity to bring his evidence, to cross-examine, not given a charge sheet, if he has not been supplied copy of the documents, or if he says do the inquiry in Hindi and it is not done in Hindi, if he is not given the option of defense representative, if he is not given a show cause notice, if there is any denial of principles of natural justice, definitely in such a circumstance, the court can surely interfere into the inquiry procedure done by the company. Then further, another interesting judgment is of Honorable Supreme Court, which says that, because this is something that we often face when we are doing inquiries in the companies, is that once inquiry officer has given the notice, and thereafter the charged employee, the charge sheeted employee, the accused employee, he stops appearing in the inquiry or he does not come at all, then the inquiry officer cannot be faulted for giving a ex parte report. But here we always suggest to companies that give 1, 2, 3 opportunities. Even if the person is not appearing, send him a notice by virtue of registered AD post, by virtue of email, give him sufficient time to appear, give him ample opportunities. If despite that he's not availing of those opportunities, fine, proceed the ex parte inquiry. But thereafter, the employee cannot complain once the opportunities have been given that the process was bad and he was not allowed to participate, if it stands proof that he has been delivered notice of participating in the inquiry. Similarly, State Bank of India, Narendra Kumar Pandey, Supreme Court said that, okay, fine, the inquiry has been ex parte, but that does not mean you hold the person guilty if he did not participate. Even in an ex parte inquiry, some kind of evidence should be there to say that the person is guilty or not guilty or whatever. So Supreme Court has said that if you're holding somebody guilty, he has not appeared, the inquiry is ex parte, but at least some evidence should be there that holds him guilty. You cannot hold a genuine person guilty just like that. Then again, Bank of India, Apurv Kumar Saha, Supreme Court again said that an employee who has refused to avail opportunities, then later on cannot say after the inquiry is over, after the report has come or the action is taken, that look, no, I did not appear, you please redo the inquiry. You give him the notice, he has received the notice, later on he cannot complain. Then further, the next judgment is of Kumau Mandal, and that says that, often you've got people like lawyers and personal professionals who are associated with the companies becoming the inquiry officer. Although under POSH Act, there are at least 4 inquiry officers, and out of this, 1 person is an outside member. So Supreme Court said that even if a paid professional like a lawyer is an inquiry officer, that does not mean the inquiry is bad. In fact, judgments like Saran Motors, etc., have said that lawyers have a good idea, a good command over provisions of law. Therefore, they have actually encouraged lawyers being inquiry officer, and merely because the lawyer is associated with the company, that would not mean that the inquiry is bad or biased. Then another very important judgment, because this is something very often happens in cases of sexual harassment and other disciplinary actions, is that as soon as there's a charge sheet, there's inquiry, there is show cause, there's a disciplinary action, the first thing the accused employee goes to court, the charge sheeted employee goes to court and says that, look, I am being victimized. I am being victimized because I am a member of the union, or because there is some political vendetta in, victimizing me. So Supreme Court has very clearly said that, look, mister, not just you allege victimization, you prove that there was victimization against you by virtue of cogent evidence. Merely you're saying things have been biased or you've been victimized, that we are not going to agree to. Another very interesting judgment is of Union Bank of India versus Vishwa Mohan. So often companies mistake. What companies do is that they give a charge sheet, they hold an inquiry, but sometimes they, out of lack of knowledge, or just because they want to hurriedly take decisions, they do not give a show cause notice, providing a copy of the inquiry report, proposing the penalty that they want to take against the employee, and straight away take the action. Now, we advise generally that you must give a show cause notice, attaching the copy of the inquiry report, even mentioning there were any past misconducts, and also proposing the penalty. But supposing if a company by default has not done that, then in such a case also the Supreme Court has said that, okay, fine, the company has mistaken not giving a show cause notice, but the employee concerned saying that, the complete inquiry that has been conducted by the management should be set aside merely for non-providing of show cause notice will not happen. The employee concerned will have to show and will have to demonstrate as to what prejudice has been, what harm has been caused to him by virtue of not supplying the show cause notice, by virtue of not supplying the inquiry report. So he cannot really ask for setting aside of the inquiry, complete inquiry, just because of one step not being taken. He has to show the harm that has been caused to him. ECIL Karnakaran, a very celebrated judgment of Honorable Supreme Court of 5 judges bench, said that, okay, yes, the prejudice has to be shown. And if a prejudice is shown, then inquiry need not be done completely from day one. Inquiry has been done, report has come, the employee been now given the report, now given a show cause notice, and now take a fresh decision. Whether he is to be reinstated in this time or he is not to be reinstated, that has been left to the committee. But the inquiry has not been set aside. A fresh show cause notice along with the report that can be given after the case went to court. Then regarding the penalties, how much jurisdiction? See, penalty is a decision of the management, and Honorable Supreme Court has time and again said that honorable courts should try not to interfere into issues of administration. So in Bharat Force judgment, Honorable Supreme Court said that the jurisdiction of the court to interfere into penalty should be only if it is shockingly disproportionate. If it is not shockingly disproportionate, then merely on grounds of compassion, sympathy, generosity, misplaced sympathy, benevolence, in such a circumstance, the punishment which has been given by the management, because management feels it is appropriate, that should usually not be interfered into, especially by the labor courts. Then Life Insurance Corporation versus Dhandapani, again the Supreme Court said that the reliefs granted by the court should be very logical and tenable. It should not be based on compassion, benevolence, sympathy, etc. It should try not to interfere into decisions of the companies, but if it feels that the penalty which has been imposed by the company was very shockingly disproportionate, the charges were not so grave, person should not have been dismissed, or he should not have been demoted, In such a case, obviously, the court has the complete prerogative to interfere, otherwise no. Now, another judgment, and this is on sexual harassment, this came before POSH Act. It's again a very celebrated judgment, is of Apparel Export Council, Promotion Council of Honorable Supreme Court. Here, the Supreme Court has very, very clearly said that, fundamental rights guaranteed in our Constitution, they include all facets of gender equality. It specifically says that committing sexual harassment would be violation of somebody's fundamental right of life, liberty, and equality. And Supreme Court has very clearly, candidly said that sympathy in such cases is completely uncalled for, no mercy is to be shown, and that the strictest possible penalty must be imposed. It's also our personal advice to companies when we advise them that, look, it is important that in cases of sexual harassment, you impose strict penalties if the charge is serious, so that a deterrent is created for future, so that other employees deter, they fear for committing such acts in future. It can actually maintain the overall peace and harmony of the organization in the long run. Then a very interesting case, this is of Delhi High Court of Dharmender versus Union of India. In this case, what happened was that the accused employee, there were certain charges of, spreading a woman's video, and that video was not very serious, but court said that, okay, fine, the video was not very serious and some minor penalty has been issued to the employee. Along with the minor penalty, the employee was also transferred to another location. So the employee went to court. Dharmender went to court and said that, look, they have given me a penalty also. They have also transferred me. So this is a double jeopardy. Court said, no, they have given you a penalty and they have transferred you for the peace of mind of the lady and for your peace of mind. That will not amount to double jeopardy. Transfer in this case or in any other case, if a person is being transferred for a misconduct, it is held to be victimizing. It is held to be bad. But in a case of sexual harassment, if a person has been transferred, that is held to be right. And that is held, it is not a jeopardy. It is not a punishment. It is a calling. It's a necessity for the situation. Then once again, Delhi High Court and Samriddhi Devi has very clearly reiterated that in a case of sexual harassment, no lenient view has to be taken, and there has to be complete followance of CCS, the Central Civil Service Rules 1965, and a very strict penalty should be imposed. Way back in the year 1960, there was a case of filthy language, and Supreme Court in the case of Odisha Cement said that for filthy language, I am not using the word rude over here, filthy, foul language. In such a case also, the penalty of dismissal has been said to be absolutely valid. Then this was another case where it says that if, the management has got bona fide loss of confidence, if the management feels the employee is not working properly, he's not good with the woman. This was not a case of sexual harassment. This was a case of something else. But court said that if management has a bona fide loss of confidence against some employee, that will be immune from challenge and the employee can be terminated. Now, this recent case of Bombay High Court, this is on sexual harassment of PVA and others. Here, very recently, Honorable Justice Patel of Bombay High Court has said that in a case of sexual harassment, the name of the witnesses, the name of the accused, the name of the victim, the inquiry report, it is not to be published, it is not to be publicized, it is not to be revealed. Even the hearings that are to be held in court, to an extent, he said it has to be in camera, nothing is to be revealed outside, nothing is to be published in media. And if media has to be informed about something, then a proper permission in writing from the court has to be taken. And this judgment is absolutely in line with the POSH Act, because POSH Act also says that everything has to be kept confidential. Then another judgment of 2021 of Madras High Court said that if it's just a case of personal misunderstanding, misunderstandings happen with everyone, all of us, personal misunderstandings, feuds, or not getting along with a colleague, that would not mean sexual harassment. There has to be some harassment, some oppression, which is sexual in nature. Only then it would be sexual harassment. A mere misunderstanding, or you're not getting along with somebody, or there are tidbits or little fights, That is not sexual harassment at all. Then similarly, in again another case of Bombay High Court, it has been said that if you are creating an intimidating atmosphere, environment for a woman employee, that would amount to sexual harassment. And here another interesting act came into place. That was the Atrocities Act of 1989. So while it was held that yes, there has been sexual harassment, but at the same time it was said that there was no act which would have attracted Atrocities Act of 1989. But yes, the charges were in line with the POSH Act, and such penalty could have been imposed. Then thereafter, Bombay High Court again has recently clarified, because there are a lot of confusions that where should the employee go with the, appeal. In this particular case, the company refused to deal with the sexual harassment complaint of the woman. So she went to High Court. And after, the High Court eventually said, relying upon a notification which was provided by the Advocate General there, which was published in the circular by the Government Gazette under Industrial Employment Standing Orders Act 1946, Section 2A, it was said that, the appropriate court for this particular case would be the Bombay Industrial Court. I may add over here that yes, there are provisions under Industrial Employment Standing Orders Act 1946, and there are circulars which says that appeals of such cases should go to, labor court, industrial tribunals. But where there are no industrial tribunals, labor courts, High Court too can entertain, because there is no other alternative remedy. And also in cases of government, as we see in other disciplinary action cases, the High Court and writ petition can also entertain. In fact, a very important recent judgment of Honorable Delhi High Court in Sarita Verma stated that, it was argued that the person should go to CAT, Central Administrative Tribunal, and fight the case. But Delhi High Court said that because the lady was close to her retirement age, therefore it was not, it was not really, it did not really appreciate that the lady should be sent all the way to CAT, and the High Court entertained the petition. So alternate remedy is there, but if High Court, if so feels, it can always entertain the complaint of the woman employee or even of the male employee. Then in Sanjeev Mishra versus Disciplinary Authority, the Rajasthan High Court said that if, a sexual harassment act need not just be at the workplace. It need not just be during the official working hours. If it is an act which is beyond the official working hours, like if somebody is sending a wrong WhatsApp message, a wrong phone call at wee hours at night, or wrong email, wrong pictures, anything, even then the employer is obligated to look into sexual harassment charges. Here, you may also refer to this old judgment of Honorable Supreme Court, that is of Mulchandani Radio. That was a case when one employee had beaten another employee outside the premises. So the argument that was leveled was that because it is outside the premises, therefore company has got no prerogative, no jurisdiction to look into the charges. But Supreme Court said that no, once there is employer-employee relationship, once both the employees belong to the same management, then definitely the company will have to look into it. Similarly, what the Rajasthan High Court has said, if the employees are of the same organization, then definitely it is the responsibility of the employer to look into the charges, even if it is beyond the premises, even if it is beyond the official working hours. And this issue has actually come up a lot in the pandemic, when most of the companies have been following work from home structure. Then Sarita Verma, which I just mentioned earlier, in this case, the Honorable Court said that yes, the jurisdiction was of CAT, but High Court entertained because the employee was about to retire. And High Court very well said that, alternate remedy is a self-imposed restraint and it is not a constitutional bar. So then further in KP Anil Rajgopalan, it has been said that, there was a statement that was made by a male employee to a female employee. It was a very normal statement which used the word abducted. And the woman employee misinterpreted it and said that it is a sexual harassment. So Kerala High Court said that merely use of abducted, that too in writing, in a very formal statement, that would not at all constitute sexual harassment. In fact, a personal advice over here, which we give to companies is that, and which we give otherwise also is that, if such kind of things start constituting sexual harassment, then they can never be genuine bona fide performance reviews of the male employees and also of female employees. Then once again, another very, very important judgment, and this is going to be celebrated in near future, is of Delhi High Court, where it has been said that cross-examination is a right of the parties, and the committees must ensure that every material, every document, every copy of witness has been duly given to both the parties, and they are both absolutely allowed to cross-examine each other, and that there is complete compliance of principles of natural justice. Now, one more judgment of Madras High Court is also a very important judgment, which has been recently very validly followed by Honorable Delhi High Court in the case of Rashi versus Union of India. It was said that the investigation has to be absolutely impartial and unbiased. And in this case of Madras High Court, because the investigation committee, the charges were against the dean, the investigation, the inquiry committee was formulated by the dean himself. And the people who were carrying out investigation against the dean, they were his juniors. So obviously Madras High Court said that if the committee is a junior to person who has committed the act, it can never be impartial. The inquiry was set aside and a new committee was formulated by the Honorable High Court. So this was a brief description about what POSH Act are, what the judgments are. However, I would want to say over here that the real intent, there are no dearth of labor laws in India. We have got Industrial Disputes Act, Contract Labor Act, Gratuity, PF, ESI, shops, establishments, factories, even now the POSH Act. There are no dearth of laws in India. But what we really lack is the implementation and the awareness. And if we can take the knowledge of these laws to the remotest parts of the country, I am sure we can actually achieve a lot more. Thank you.
Thank you, Ravi ji. यही अगर फिजिकल होती तो क्या बंदे कैसे
जिनका माइक चल रहा है माइक म्यूट कर ले प्लीज.
रावी जी का बहुत बहुत धन्यवाद. अब हमारा क्वेश्चन आंसर सेशंस है. इस वक्त हमारे साथ दोनों ही स्पीकर जुड़े हुए हैं. कुछ प्रश्न आए हैं मेरे पास जो दोनों स्पीकर्स के लिए हैं. सबसे पहले मैं सुनीता जी से पूछना, एक प्रश्न आया है सुनीता जी के लिए. दीपक जैन जी ने पूछा है, कैन हगिंग और होल्डिंग अ पर्सन बाय द शोल्डर और वेस्ट और एनी सच एक्ट विदाउट एनी मैलिफाइड इंटेंशन बी कंसिडर्ड एज सेक्सुअल हैरेसमेंट?
दीपक जी का सवाल है, राइट रितु जी? जी दीपक जी, मैंने एक बात कही थी, द एक्ट looks at it says intent. What is the intent? That becomes, that's not important. What is the perception? If the woman felt कि by hugging or by holding her hand, if she felt violated, if the behavior was unacceptable, so the totality of circumstances, अगर किसी ने हाथ किसी ने कंधा हटाया, that means non-verbal way में the woman showed it that I do not approve of this behavior. So the conduct जिसकी बात हम कर रहे हैं, it is not examined in abstract. It is examined in a particular context. And the most important thing is, how did the woman perceive it? So the best is, one is, of course, to act with abundant caution. That is number one. Secondly, अगर कोई ऐसा कंप्लेंट का इन्वेस्टिगेशन आता है, तो उसको आप देख के ये बात कि क्या है, in what circumstances has she said that she found this act offending, वो आपको इन्वेस्टिगेट करना पड़ेगा. अगर आपके पास समय है तो मैं एक रेफरेंस दे सकती हूँ. एक ऑस्ट्रेलियन कोर्ट का बड़ा फेमस जजमेंट है और उसके क्रॉस एग्जामिनेशन में निकल के आया कि वहां पे एक बॉस के अगेंस्ट, इट्स अ रिपोर्टेड जजमेंट बिकॉज ऑस्ट्रेलिया वगैरह में वहां पे पहले द जूरिस्प्रूडेंस स्टार्टेड डेवलपिंग, तो बॉस के अगेंस्ट सारी महिलाएं थी वहां पे, उन्होंने कंप्लेन की क्योंकि वो बड़ा सेक्सिस्ट जोक मारा करते थे. So one of his defense was that यहाँ पे सारी महिलाएं हैं, it is me who is alone, it is I who feel, or never, that they have never turned around and said no to my either jokes or whatever that I crack. हाँ, तो उनके क्रॉस एग्जामिनेशन में एक जवाब भर के आया कि did you not notice कि जब आप ऐसा बिहेव करते थे तो हम लोग ड्रॉर जोर से मारते थे या निकल जाते थे. So those were, and the court in the final judgment, it's written very beautifully, and it says that those were the non-verbal way of showing disapproval of a conduct. So go back to the triangle. If it is unacceptable, non-invited, अगर मैंने आगे बढ़ करके सिंपल, अगर हाथ मिलाने में भी एक सिंपल कटसी का रूल होता है, अगर महिला ने पहले हाथ बढ़ाया तब आप हाथ मिलाइए. ये सोशल कॉन्डक्ट है. होप दैट आंसर्स योर क्वेश्चन दीपक जी.
अगला प्रश्न रावी जी से है. वुड फ्लर्टिंग इन द ऑफिस काउंट एज सेक्सुअल हैरेसमेंट?
सर, फ्लर्टिंग वुड काउंट एज सेक्सुअल हैरेसमेंट एनीवेयर, चाहे वो ऑफिस में है, वो बियॉन्ड द वर्किंग आवर्स है, वो बियॉन्ड द ऑफिशियल आवर्स है, वो बियॉन्ड द वर्किंग प्लेस है. दैट वुड फ्लर्टिंग इज अ सेक्सुअल हैरेसमेंट एनीवेयर.
हमारा अगला प्रश्न भावना जी ने किया है सुनीता जी से. डज आइंग और स्टेयरिंग एट समवन काउंट एज सेक्सुअल हैरेसमेंट?
आइंग, ओगलिंग जिसको कहते हैं अंग्रेजी में, और हिंदी में कहें तो ताड़ना बोल सकते हैं, हमारी तरफ तो ताड़ना कहते हैं, ठीक है. तो फिर मैं वही डेफिनेशन पे जाऊंगी, परसेप्शन और हाउ हैज द वुमन परसीव्ड. इफ आई फेल्ट अनकंफर्टेबल, अगर कोई आपको देखे जा रहा है, और देखने की भी बड़ी बड़ी तरीके होते हैं, if you are watching a woman below her neck, if you are watching her around her chest or any exposed part of her body, it's clearly not, it's making her feel uncomfortable. It is sexual harassment at workplace. And if it persists over a long period of time, it will create what is called a hostile work environment. And ogling is, it is, आप सेक्शन में भी देख लीजिए, किसी भी तरह का वर्बल, नॉन वर्बल, सेक्सुअल इंटेंट की जरूरी है. क्योंकि दो तरह से, एक हम ईश्वर को भी देखते हैं, बड़े ये से भी देखते हैं, बड़े हम अगर मूर्ति में खड़े होइए मंदिर में तो हम बड़े श्रद्धा के साथ देखते हैं. वो देखना एज एन एक्ट की बात नहीं हो रही है यहाँ. देखना जिसको आप कह रहे हैं ना, स्टेयर करना, तो वो जरूर आएगा मेरे हिसाब से. अगेन, the whole act will have to be analyzed in a context and the factual allegations made in the complaint.
अगला प्रश्न रावी जी से. If someone goes to cover an official event organized at outside venue and she gets sexually harassed there by someone else, means outside his office colleagues, whether she can still make a complaint of sexual harassment before her committee?
This is very interesting. I think what the question is wanting to say that the accused male employee, probably he does not belong to the organization, but the victim belongs to organization. She can go a complaint, but one thing is to be noted. See, POSH Act has only got the power to do an inquiry and to recommend a disciplinary action, right? Apart from that, POSH Act says that if there is a complaint, that the company has to assist the woman employee, take it to court. So the company cannot do an inquiry into this because the male employee is not the employee of the company. The company cannot take a disciplinary action. It cannot terminate him because there is no employment contract. The worst action that a company can take against a person is removal, dismissal, termination. That company obviously cannot do against the accused employee. But saying that if she takes such a complaint, while the company cannot do any inquiry because there is no reason to do the inquiry, there is no possibility of doing the inquiry, the company cannot take disciplinary action. But at the same time, company will have to assist her, take this complaint to the local complaint committee. The district committee as well as the company will have to assist her that following the provisions of Indian Penal Code, take this case to the police or to the concerned criminal code. So she can make a complaint, but company cannot inquire. It cannot hold inquiry. It cannot take disciplinary action, but it will have to assist her going to local complaints committee or to the criminal code or to police or any other appropriate remedy that the woman wants. If she does not want, then she does not want.
अगला प्रश्न श्री एस त्रिपाठी जी का है, सुनीता जी से. हाउ कैन आई नो एज अ विक्टिम that the committee will be fair or that the harasser cannot influence the committee?
देखिए, कमिटी आपकी ऑर्गेनाइजेशन की है, ठीक है. इनका बेस्ड ब्रॉड बेस्ड होता है, जो 5 मेंबर्स होंगे और एक इसमें एक्सटर्नल मेंबर को भी शामिल किया जाता है. So by law, the procedure, the structure of the committee is as such कि आपको fair hearing मिले, fair inquiry हो, ठीक है. इसके बावजूद अगर कोई स्पेसिफिक रीजन से आपको लगता है कि कमिटी बायस्ड होगी या कमिटी को इन्फ्लुएंस कर सकती है या कोई पर्टिकुलर पर्सन से आपको लगता है कि ये पर्सन, तो आप वो ऑब्जेक्शन डाल सकते हैं कमिटी के सामने. वो ऑब्जेक्शन आप डाल सकते हैं. बट the thing is, at some point of time, we also have to trust our own institutions, our own structures, right? To give, and that's the whole point of the training and knowing what the law is and upholding what the right procedure is. So I'm not saying the committee does not go wrong or does not. We hear these kind of cases on a day. We appeal, we file appeal. But the fact remains कि you go through the procedure. अगर आपको किसी खास वजह से लग रहा है, आपको लग रहा है कि आपको, जैसे कि अभी रावी जी ने अपने प्रेजेंटेशन के दौरान बताया कि every document has to be shared. रिप्लाई आई, जो जवाब आया, सवाल, वो सब इनको शेयर करना है. अगर लग रहा है कि कमेटी नहीं शेयर कर रही है, मुझे राइट इन्फॉर्मेशन नहीं मिल रही है मुझे, तो फिर आपको तो आपके दिमाग में ये सस्पिशन हो सकता है कि भाई फेयरनेस कहीं पे कॉम्प्रोमाइज हो रहा है. तो आप ये बात कमेटी के सामने भी उठा सकते हैं. कोई एक पर्टिकुलर मेंबर से है तो वो बात को भी आप वहां पे रख सकते हैं कि दिस पर्टिकुलर पर्सन बिकॉज ऑफ ABCD रीजन हमें अनकंफर्टेबल है. But I would suggest that if there is a committee within the organization with right people, it should do their job well. That is what expected of them.
अगला प्रश्न आशीष जी का है और सुनीता जी आप पहले ही उसका उत्तर दे चुकी है. मैं प्रश्न फिर भी आपको बता देती हूँ. If the committee is biased or unfair or non-cooperative, what are the remedies for the victim against the working of the committee?
जैसा कि मैंने कहा कि एक तो आप कमेटी के सामने ही वो सवाल उठा सकते हैं कि भाई मुझे ये चीजों से प्रॉब्लम है. दूसरा ये है कि अगेन अगर आप वहां, आपके पास फिर लोकल कंप्लेंट्स कमेटी का भी एक उपाय है. यू कैन गो एंड एक्चुअली there are a lot of cases where people go and file their cases saying that look, we do not trust this process. So that is something that they can do.
हमारा अगला प्रश्न जसप्रीत जी का है रावी जी से. Is there any specific law for the grievance of man at workplace when he is also subjected to sexual harassment?
This question comes in every webinar I do. कि भाई क्या है? What is there? See, the thing is, I cannot answer saying that, I mean, the General Clauses Act says that he and she, he will mean she and she will mean he. Normally क्या होता है law में that, he is taken to be she is taken to be he. Even if the law is using the word he, that would obviously include she. But if you see the name of the act, that is Sexual Harassment of Women, Prevention, Prohibition, Redressal. The name of the act itself uses the word woman. The preamble of the act itself uses the word woman. Everywhere it has been said woman. But here I may also tell you that recently there is a judgment of, I think it is of Calcutta High Court or it is of Madras High Court. There it has been said that if it is a complaint between the same genders, there were 2 women. If it is a complaint by the same gender, that is a case of one doctor, some doctor, then that would be entertained under the POSH Act. So as of now, the prima facie interpretation is that, things like domestic violence hai. So things like
I think we have lost connection with Ravi ji. So as she was saying, if I'll just take it up and add 2 lines to that. The act talks about aggrieved woman. जो कंप्लेन कर सकती है वो अग्रीव्ड वुमन है, तो जेंडर में कोई कंफ्यूजन यहाँ पे नहीं होता है। हालांकि जो रिस्पोंडेंट है उसको लिमिट नहीं किया गया है कि रिस्पोंडेंट कैन ओनली बी मैन, बिकॉज रिस्पोंडेंट कैन एनी बी। सो माय सिंपल रीडिंग ऑफ इन माय अंडरस्टैंडिंग द allegation can be against both. Having said that, I do want to add one more thing, because there is something called a policy. Every organization can make their own policy, and I want to share this from this August gathering कि बहुत सारी big companies, international companies हैं जिनका reach is not just one country but across. They have policies not just for men but also for transgenders. So all that is included, all those behavior is also included. So while there is one that is law, and then another there is a policy. So through their policies, organizations have tried to give the benefit through their general grievance redressal mechanism to men as well as persons, transgenders, and to make it more wide in terms of its scope.
अगला प्रश्न आप सुनीता मैम जसप्रीत जी का आप ही से है. Does this act, means Sexual Harassment Act, also extend to the scope where any other outsider woman or non-employee or woman client or customer has been sexually harassed at any workplace? Means where she is not working, a woman's come there and she is sexually harassed.
Yes, I had said about the what I said, remember about third party liability. You have third party liability under the act. So therefore, the victim need not be your employee. Victim need not be your employee, and therefore she can be a visitor to your organization, she can be your client. So please do go through that section.
मैम एक सिमिलर क्वेश्चन है, आई थिंक उसका भी आंसर आप ही ने दे दिया एक बार. मैं वैष्णवी जी का प्रश्न है ये. If someone who is working in the company voluntarily and is not employee as per law, it may be on contractual basis, whether can he be charged as sexual harassment for his misdeeds? It means the accused person over here.
So two things we have to remember. The definition clause mein, who is an employer and who is an employee. All right, first I will come because the question deals with employee. So employee is not only somebody who is on the roll of the company. It could be voluntary, it could be for a stipend, it could be a consultant, it could be an intern, it could be somebody who is even not working for any remuneration. आप वो definition section 3 इसकी पढ़िए, section 2 का, sorry, who is an employee? Ad hoc, daily wage basis, directly, indirectly, probationer, training, apprentice, called by any such name. So as I said, the definition is extremely wide. For employer, there are 3 things which needs to be seen, because बार-बार ये भी सवाल उठते हैं बहुत सारे cases में कि वो employer है कि नहीं. Employer is power of superintendence, of management. If somebody can manage my time, if somebody can, superintend. So power of management, superintendence and control. ये 3 keyword हो जाते हैं in identifying who is the employer. तो cover होगा. That's the long and short of it. Ritu ji, you are on mute.
रितु जी अपने आप को अनम्यूट कर लो.
अगला क्वेश्चन उमा जी का है रावी मैम से. Is there any remedy in the law or act if any woman employee takes advantage of this act, means this law, and blackmails the accused person for benefiting herself, for benefiting herself?
बिल्कुल है. कंप्लेंट इसमें या तो प्रूव्ड होती है या नॉट प्रूव्ड होती है, लेकिन एक तीसरी और चीज होती है. वो है false and malicious complaint. कमिटी जो इन्वेस्टिगेशन करती है उसमें रिपोर्ट दे सकती है कि ये प्रूव्ड है कंप्लेंट, नॉट प्रूव्ड है, और तीसरा जो रिजल्ट देती है वो है कि कंप्लेंट वाज फॉल्स एंड मलिशियस. इनफैक्ट उसके बाद एक सेकंड लेवल ऑफ प्रोसीडिंग शुरू होती है टू डिटरमिन, क्योंकि एक्ट कहता है कि द सेम लेवल ऑफ पनिशमेंट जो रिस्पोंडेंट को दी जाती इन केस ऑफ अ फॉल्स एंड मलिशियस कंप्लेंट वुमन को भी दी जाती है. So therefore the law has remedy. It's very strong. That remedy is, it's important to talk so that, you know, one is very much aware. The complaint may not be proved, that is fine. But if it is being used for a blackmail, as you said in your question, then it is malicious. And there is a punishment, the same punishment, or perhaps more. Then the committee will determine it separately. So yes, there is a remedy.
मैम अगला क्वेश्चन हुमा जी का है. Please define indirect sexual harassment. Is there
Okay,
any
direct. No, sometimes, see, the thing is, sometimes it can be very direct, all right? And sometimes the acts, and where people have come, you know, if you sit in the committee and realize the kind of complaints which come, जहाँ पे बातें बड़ी coverted होती हैं, covered होती हैं, directly कोई नहीं बोल रहा है, but indirectly आपको indication दी जा रही हैं. You have to read between lines. So that all that is also gets covered. Indirect. Directly जी मैंने कुछ नहीं कहा कि हाँ चलिए कुछ आपको गलत बात बोल दिया या बिल्कुल ऐसा. But indirectly हम बोले जा रहे हैं. ये वो ogling वाली भी बात हो जाएगी. Directly तो कुछ नहीं है लेकिन indirectly है. बिल्कुल है indirectly. And it is there in the definition itself. So it's nice, you should just read that section. Section 2 में जितनी definitions है पढ़िए, सारी बहुत डिटेल्ड है.
मैम अगला क्वेश्चन है अंजू जी का. कंप्लेंट पर इंटरनल कंप्लेंट कमेटी इस बात पर उसका जो जजमेंट आता है कि कंप्लेंट जो है वो फॉल्स है. एक लेडी की कंप्लेंट पर जजमेंट आता है कि इंटरनल कमेटी कहती है आपका कंप्लेंट फॉल्स है. What will be the action taken against the complainant in the absence of service rules, if there are no service rules? And committee come to the conclusion that complaint is false and malicious.
हाँ, so like I was, रितु जी, if you remember in the other case, उन्होंने पूछा था रेमेडी का. तो जैसे कमिटी क्या है कि कमिटी ने अपना कमिटी एक सेक्सुअल हैरेसमेंट कंप्लेंट को इन्वेस्टिगेट कर रही है. कंप्लेंट ए, कंप्लेंट कमिटी की फाइंडिंग आई कि द कंप्लेंट इज नॉट प्रूव्ड. ऑलराइट, उसके बाद कमिटी ने यह भी कहा कि दिस कंप्लेंट लुक्स लाइक अ false and malicious complaint. All right. Now the employer will have to separately institute a second, because आप उसी इंक्वायरी में नहीं जा करके, क्योंकि एक false complaint करना अपने आप में एक अपराध है under the service law. You cannot do that. तो उस पे एक committee will again sit down, offer her opportunity, let her explain, because the same policies, procedures will be followed, and then give the suitable punishment. It is not, because that's the standard, that's a standard procedure. It may not have a company rule, but there is a law. They may not have a service rule for punishing a complaint, but the punishment for a complaint is coming from the law. It's flowing from the act. तो बिल्कुल हो सकता है.
Next question is from Mr. Dharminder. Whether this act applies to small workplaces where 15 to 20 workers are working?
Absolutely, 10 or more.
Can complainant file FIRs at the same time along with the complaint made to an internal committee or local committee?
There is no prohibition.
Next question is from Mr. Kunal. How this act will be different from other sections of IPC such as 354, 509 and 376 IPC?
हाँ जी, रावी जी आ गए हैं अभी हमारे. तो like I said, हम आप ये IPC के सेक्शन की बात कर रहे हैं, 376. नहीं, ये अगर आपका कंप्लेंट FIR है, if it is a complaint to the police, it is under the criminal, it's under the criminal realm of criminal jurisdiction. तो वहां पे भी FIR दर्ज होगी, इन्वेस्टिगेशन होगी, रिपोर्ट फाइल होगी, सब कुछ होगा। लेकिन जो हम एक्ट में ऑर्गेनाइजेशन के अंदर आप डाल रहे हैं कंप्लेंट, या फिर आप लोकल कंप्लेंट्स कमिटी को डाल रहे हैं, डिस्ट्रिक्ट कंप्लेंट्स कमिटी को डाल रहे हैं, दैट इज अ सिविल प्रोसीजर, जहां पे जो भी सर्विस रिलेटेड पनिशमेंट्स हैं उसके साथ अवार्ड, कंपनसेशन, ये सब बातें आती हैं। सो दैट इज अ सेपरेट, क्रिमिनल इज अ सेपरेट प्रोसीडिंग।
अगला क्वेश्चन रावी मैम आपसे है, डज दिस एक्ट प्रोवाइड for compensation or damages?
Sorry, can you kindly repeat the question? I got disconnected. I'm so sorry in the middle. Kindly repeat the question.
Does this act provides for compensation or damages to the aggrieved person, and who will be responsible to pay?
Sure. See, the act does not define what the amount of compensation would be, but the act definitely states that apart from disciplinary action, if the charges stand proved, then amount of salary, which can also mean the amount of retiral dues like the gratuity, leave encashment, notice pay, or any other due except for Provident Fund and ESI, that can be deducted from the dues, the salary of the accused male employee, and be given to the victim female employee. What that amount would be, that will totally be the recommendation of the inquiry committee and the final decision of the disciplinary authority. How that compensation is to be calculated, that would depend upon the kind of harassment that has been caused, the mental trauma that has been caused to women, what kind of charges were leveled. The provision is there, but the money is to be taken from the pocket of the male employee and to be given to the female employee, to be decided by the employer, the disciplinary authority.
रावी मैम, अगला क्वेश्चन आस्था जी का आपसे है, how this act is different from guidelines laid by the Honorable Supreme Court on sexual harassment of women at workplace in the case of Vishakha versus State of Rajasthan 1997.
See, the major difference is that, like I said when I was showing the PPT also, is that, Vishakha laid down guidelines, but if the guidelines given in Vishakha, they were not followed, right, then there were no penal consequences. Follow nahi kiya, okay, fine. Vishakha said have an inquiry committee in place, management is not having, no problem. But the POSH Act says, the 2013 Act says, if you do not have the internal complaint committee which has been given in the Act, if you do not have a policy in place, if you do not inform about the policy to the employees, if you do not take disciplinary actions, against the male employee, or if there is any other non-compliance, including not giving the annual report to the appropriate government every year, then there can be penal consequences like imposition of penalty of 50,000 as cost. If you again repeat the offense, there can be double penalty. At the same time, your registration, your license to carry on the work will go. It can be taken away by the labor department or the concerned department or even the court, and you cannot carry on the business that you're doing. Vishakha did not have these penal consequences, and that is the major difference. Apart from that, Vishakha gave general guidelines which were very helpful. In fact, when the act was promulgated, when the provisions were being framed, Vishakha guidelines were completely relied upon. However, the guidelines and the provisions, how the committee has to be there, what number of members, how many females, how many males, what is the procedure, that have been precisely defined in the Act. That is the major difference.
My next question is, Sunita ma'am, can further inquiry or complaint be made once settlement has been arrived?
Okay, so see, there is a process of what is called conciliation in the Act. So if woman gives in writing saying that I want this to be conciliated, so that conciliation can happen, and whatever settlement takes place, then it becomes a part of the inquiry, part of the report. having said that, you cannot have financial settlement, etc., etc. Those are the guidelines are there in the Act. Now, the question, to my understanding, it says that if the settlement has already happened, then
Yes.
can the complainant come back and say that, look, you reinvestigate? What is the reason? Are the agreed terms not being complied with? Is she saying that settlement happened due to some force? You see, something will have to be shown. That why is this not being done? Why is this settlement not acceptable to me? Because settlement under the POSH Act can only happen after woman makes a written request for such a settlement. So that would be my limited response to this question, unless Raviji wants to add something to it.
आपने बहुत अच्छा कहा, बहुत अच्छा कहा आपने. Once settlement is done, it's done. आपने settlement accept कर लिया, then you can't say that I'll keep the amount also and I would want to contest the case also. So I agree with Sunita.
रावी मैम, एक क्वेश्चन है अजय जी का आपसे. Is there any remedy for men when relation is consensual in nature?
See, if it is consensual and consensual in nature, and that is something that you will have to actually prove, right? And there has been a recent judgment of Delhi High Court where it was said that, okay, it was consensual. And therefore, the court said that, no, this would not amount to sexual harassment. So if the male is able to prove it, definitely that would, in my personal view also, I also agree with the judgment of the Honorable Delhi High Court, that would not amount to an act of sexual harassment at all, because there is an angle of consent there.
I'll just
it is something,
yeah.
it is something, which the male is doing without the female liking it. But if it is a friendship, and if it is, there's a mutual relationship, then later on you cannot. I've personally done lots of cases like this, that, even when the woman is friendly and the man is friendly, and later on it turns out to be something else totally. So if there is an element of consent involved, definitely we cannot hold the man guilty unless he has done something which is absolutely absurd. Like, see, supposing there is a consent to a light or a healthy friendship, but if he does something which is physically wrong, that situation may be different. But if it is overall, there's a consent, there is friendship, and, it may not really amount to sexual harassment. And in such cases, it is better to make the parties sit and to settle the issue.
I just wanted to add a little to that about the consensual part. So one of the earliest, the whole jurisprudence of sexual harassment is the Meritor saving case, which is on the issue of sexual relations between the boss and the teller, the banking teller. And, and that the US Supreme Court was called upon to say whether it amounts to sexual harassment at workplace or not. So just to cut the story short, those who have time, please just Google Meritor saving and you will see the judgment. You must read it, because it basically, that is the story of jurisprudence which starts and which talks about looking at the issue as a gender discrimination. Anyway, coming back to the present, consensual will also, what will depend on what is the power relationship. If there is a reporting relationship, if the woman is reporting to the person, man, then the consensual itself becomes problematic. So therefore, even if one has to enter into any consensual relationship, then ensure that the person who is working should not be working under or reporting to or that sort of a situation. Because if there is power, there is a presumption that, there was the woman gave her consent, thinking that it could, again, the quid pro quo. Yes, sorry.
I would just want to add over here, the POSH Act itself says, when we were discussing the PPT, that a promise of preferential treatment or a threat of detrimental treatment, that would also amount to sexual harassment. So once we use the word consent, we are assuming that there is consent, that there is absence of preferential treatment, that there is threat of detrimental treatment. So consent means pure consent, where there is no undue influence, force, and coercion involved. So when the word consent is used, It means a pure consent. It does not mean because of any benefit attached to it.
अब मैं इस क्वेश्चन आंसर सेशन का समापन करते हुए श्री नरेंद्र कालरा जी को आमंत्रित करना चाहूंगी कि वो अपना वोट ऑफ थैंक्स प्रस्तुत करें.
थैंक यू रितु जी. आई एम ऑडिबल?
जी
जी सर.
फर्स्ट ऑफ मैं सबसे पहले थैंक्स करना चाहूंगा अपनी तीसरी यूनिट को, जिन्होंने इतना बढ़िया आज का वेबिनार ऑर्गेनाइज किया. सेकंड थैंक उन सब लॉयर्स को जिन्होंने, जो लॉयर्स नहीं भी थे, उन्होंने इस वेबिनार में अपनी अटेंडेंस लगाई और अपने समय दिया इसको सुनने के लिए. और इतने बढ़िया स्पीकर थे आज के. वाह वाह, क्या बात है. इतने स्विफ्टली उन्होंने क्वेश्चन आंसर का जवाब दिया, क्वेश्चन को आंसर किया. एंड आई वुड से दैट Ravi was and Ahmed Jha Sahab was thorough on this subject. I would learn and listen to more and more from both of you. I love to listen to you. I'm grateful and thankful to both the speakers of today. So thank you very much for joining this webinar. Thank you for giving time to us. Thank you for guiding on a wonderful subject. I am indebted. I am say मेरे पास शब्द नहीं है आपका बयान करने के लिए कि जितना ब्यूटीफुल आपने चेक को एक्सप्लेन किया. और मैं ये सोच रहा था कि रावी भी 2-4 जजमेंट के बाद बस कर देगी, बस थॉरो जज वाज साइटेड बाय हर. तो बहुत बहुत धन्यवाद रावी जी आपका भी, और सुनीता जी आपका भी, और सभी लोगों का बहुत तहे दिल से धन्यवाद जिन्होंने इस वेबिनार में अपनी उपस्थिति दर्ज की और इसको धैर्यपूर्वक सुना. थैंक यू वेरी मच
सर. सबकी तरफ से आपको बहुत बहुत धन्यवाद सर, कालरा साहब और जैन साहब, और इस प्लेटफॉर्म के माध्यम से हम लोगों को इतना इंटरैक्ट करने को मौका मिला हमारे इतने लॉयर फ्रेंड्स से, तो ये हम अपनी सौभाग्य समझते हैं अपना, और वी लुक फॉरवर्ड टू पार्टिसिपेट मोर एंड मोर. थैंक यू.
आपको बहुत
एक सूचना सर
मैम को भी टू गाइड अस एंड टू एनलाइटन अस ऑन द डिफरेंट सब्जेक्ट्स.
सर
रितु जी.
साहब
प्रदीप जी कुछ कहना चाह रहे हैं शायद.
हाँ, ये कहना चाह रहा था कि हम सभी लोग अब चूंकि काफ़ी दिल्ली से बाहर के रहने वाले हैं, यूपी और सभी जगह पे 4-5 स्टेटों में इलेक्शन होने जा रहे हैं, तो एक तो सभी से अनुरोध है कि सब अपना अपना मत का प्रयोग जरूर करें जहाँ भी अपने स्टेट से, और मत के साथ साथ मत जरूर करें, और मतदान करते समय ये जरूर ध्यान रखें कि हमें राष्ट्र के निर्माण में अपना भागीदारी सुनिश्चित करनी है. तो इस प्रकार से मेरा ये.
अब मैं यहाँ पे उपस्थित सभी लोगों का बहुत बहुत धन्यवाद करना चाहूंगी कि इस प्रोग्राम में अपना समय देने के लिए और आने के लिए बहुत बहुत धन्यवाद. और आप सभी से अनुरोध है कि राष्ट्रगान के लिए इस वर्चुअल प्लेटफॉर्म्स के माध्यम से हमारे साथ जुड़े और राष्ट्रगान के लिए खड़े हो जाए.
जन गण मन अधिनायक जय हे भारत भाग्य विधाता, पंजाब सिंध गुजरात मराठा द्राविड़ उत्कल बंगा, विंध्य हिमाचल यमुना गंगा, उच्छल जलधि तरंगा, तब शुभ नाम में जागे, तब शुभ आशीष मांगे, गाए तब जय गाथा, जन गण मंगलदायक जय हे भारत भाग्य विधाता, जय हे जय हे जय हे जय 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 जय. भारत माता की जय.
Once again, I am thank you very much for joining us.
धन्यवाद.